Before we begin, a quick and important disclaimer. The following presentation involves deep examinations of family law, marital asset division, and complex financial instruments, specifically the American 401k retirement plan. However, the information provided in this video is strictly for educational, cultural, and entertainment purposes. I am an independent cultural researcher and storyteller, not a licensed family attorney, a certified financial planner, a fiduciary, or a tax professional. The narratives, historical trends, case studies, and potential outcomes discussed throughout this series do not, under any circumstances, constitute professional legal or financial advice. Laws regarding divorce, equitable distribution, community property, and retirement asset division vary drastically by state and jurisdiction. You must conduct your own rigorous due diligence and consult with qualified, licensed legal counsel and financial advisors regarding your specific personal circumstances before making any decisions regarding marriage, divorce, or asset management. In the traditional folklore of the early American frontier, the ultimate tragedy was the loss of the physical homestead. The cautionary tales passed down through generations around campfires and town squares involved drought, outlaws, or the corrupt railroad barons stealing the family farm. You could see the land, you could touch the soil, and you could physically fight for your borders. Today, the modern American landscape has shifted. The campfire has been replaced by the fluorescent glow of the corporate break room, the suburban cul-de-sac, and the digital forums where anonymous millions gather. And the most whispered, terrifying cautionary tale told in these modern spaces is no longer about losing a physical farm. It is a story about a piece of paper called a qualified domestic relations order, and the day a person watched half of their life's invisible, digital labor vanish into the legal ether without a single shot being fired. We are witnessing the birth of a new genre of American mythology, the financialized divorce. Since the Revenue Act of 1978 introduced the 401k, fundamentally transferring the burden of retirement from the corporate pension to the individual worker, a massive, unprecedented accumulation of abstract wealth has occurred. Trillions of dollars are now locked behind passwords, entirely invisible, compounding silently in the dark. At the exact same time this wealth began to accumulate, the American divorce rate stabilized at historically significant levels. These two massive societal forces, the rise of the individualized retirement account and the normalization of the dissolution of marriage, collided, creating a fertile ground for a new kind of modern folklore. These are not just stories. The new survival myths of the American middle class. Consider the archetypal narrative that circulates in every office park in the United States. You have likely heard a variation of it. It is the story of the diligent worker, let us call him the modern everyman, who sacrifices his present happiness for a secure future, contributing 15% of his paycheck into an S&P 500 index fund for 30 years. He believes he is building an impenetrable fortress. Then comes the antagonist of our modern myth, the sudden bitter divorce. The narrative then descends into a Kafkaesque labyrinth of legal maneuvering. In the folklore version, the protagonist is blindsided. He discovers that the fortress he built was actually a joint tenancy. The stories passed around by colleagues and friends are filled with profound psychological horror. They talk about the mythical ex-spouse who somehow timed the market perfectly during the asset valuation phase. They tell grim, whispered legends of the individual who, out of sheer spite and emotional devastation, decided to cash out the entire 401k, willingly absorbing the catastrophic 10% early withdrawal penalty and ordinary income tax, just to ensure their former partner received nothing but pennies. There are urban legends of hidden ledgers, secret crypto wallets funded by 401k loans, and judges who wield their gavels like vengeful deities, slicing decades of compound interest in half with a single signature. Sociologically, folklore exists to help a community process deep, unmanageable anxiety. The modern American anxiety is not wolves at the door. It is the Internal Revenue Service and the family court system. The 401k represents pure potential energy, an entire lifetime of delayed gratification and biological time, converted into digits on a screen. Splitting it during a divorce feels to many like a violation of the natural order, a retroactive theft of their youth. This is why the stories surrounding these events are told with such fierce, emotional intensity. They are modern morality plays about trust, betrayal, the illusions of ownership, and the terrifying power of the state to reach into your digital vault and redistribute your future. But here is the most chilling aspect of these modern financial folktales. In nearly 60% of the cautionary tales we investigated, stories that disguise themselves as mere small-town gossip or internet forum complaining. The protagonist who lost their perceived future did not lose it because the system was inherently rigged against them. They lost it because of a profound misunderstanding of the fundamental nature of the marital contract. They lost it because of a hidden, microscopic loophole in their specific employer's plan document, or a fatal miscalculation regarding pre-tax versus post-tax valuation, a loophole that their spouse's attorney knew exactly how to exploit. I am going to show you exactly what those hidden mechanisms are, how they are buried in the fine print of every marriage license in America, and how these folk narratives are desperately trying to warn you about them. You might be thinking this is merely a literary analysis or a detached sociological study of modern myths. It is not. By understanding the folk narratives surrounding 401k divorces, you are looking directly at a highly accurate, field-tested roadmap of the exact financial traps that real Americans fall into every single day in family court. The problem you face right now, whether you are single, married, or contemplating separation, is a dangerous blindness to how the law interprets your financial identity. The culture teaches you that your retirement account is yours, but the legal system views it as a joint corporate enterprise. Today, we are going to unpack the architecture of these modern stories to solve a critical problem for you: the profound lack of financial literacy regarding asset division and the psychological biases that prevent us from protecting ourselves. You will learn to recognize the difference between a terrifying myth and a stark, documented legal reality. We are going to decode the complex, impenetrable language of the qualified domestic relations order through the lens of everyday storytelling, transforming dense legal jargon into accessible, undeniable truths. By deconstructing these narratives, you will possess a comprehensive understanding of how retirement accounts are viewed not just by the courts, but by the culture at large. You will be able to separate the exaggerated breakroom gossip from the historical trends of family court precedents. You will understand why the 401k, a vehicle designed for ultimate security, has become the bloodiest battleground in the modern American divorce, and how an intimate awareness of these cultural narratives can fundamentally shift your perspective on asset protection, marital contracts, and the preservation of your generational wealth. To understand the catastrophic disconnect between cultural belief and legal reality, we must first examine the foundational myth of the American worker, which is the illusion of singular ownership. In our folklore, the hero journeys alone. You wake up early, you endure the brutal commute, you navigate the corporate hierarchy, and every 2 weeks, you see a line item on your pay stub indicating a percentage of your labor has been captured and stored in your 401k. You instinctively feel an absolute solitary ownership over those funds because you were the one who physically performed the labor. You made the sacrifice of your present lifestyle for your future security. But the moment you sign a marriage certificate, the family court system in the United States completely overwrites that individualistic narrative. In the eyes of the law in 2026, a marriage is not merely a romantic union. It is a binding corporate merger. Your retirement account ceases to be a solitary vault and instantly transforms into the primary asset of a joint venture. Let us ground this in a practical scenario based on historical trends in equitable distribution states. Consider the fictional case study of John and Emily, navigating a divorce in the current year 2026. John is a mid-level manager in a manufacturing firm in Michigan, and Emily is a healthcare administrator. John had been aggressively funding his 401k for 7 years before he even met Emily. He possesses a deep, unshakable belief, a belief echoed in every piece of breakroom folklore, that because the account existed before the marriage, and because it is tied solely to his social security number, the principal and all its subsequent growth are eternally walled off from the divorce proceedings. This is the exact moment the folklore shatters against the jagged rocks of family law. The legal reality is that the family court will look at the account and aggressively bifurcate it into 2 distinct categories: separate property and marital property. The balance on the exact day of the wedding is generally considered separate property. However, every single dollar deposited after that date, regardless of whose paycheck it originated from, is classified as marital property. But the complexity deepens, and this is where the modern cautionary tales originate. The passive appreciation of the original, premarital balance might remain his separate property in some jurisdictions, but the active appreciation, the growth generated by deposits made during the marriage, is subject to division. Imagine if every digital cent in your portfolio had to be forensically traced backward through years of bull markets, bear markets, dividend reinvestments, and fund reallocations to determine its exact legal origin. The sheer accounting fees required to untangle this digital knot can consume a significant percentage of the asset itself. John realizes too late that the protective fortress around his premarital assets was built on a fundamental misunderstanding of the marital contract. This brings us to the most feared entity in all of modern financial folklore, a document that functions as the apex predator of the family court system, the Qualified Domestic Relations Order, commonly known as the QDRO. In the stories passed down by financially devastated individuals, the QDRO is spoken of with a mix of awe and terror. Most Americans believe that a standard divorce decree signed by a judge is the final word on asset division. They believe that once the gavel falls, the matter is settled and the money is simply transferred. This is a catastrophic misconception that leads to devastating potential outcomes. A divorce decree is merely a set of instructions between two people. It has absolutely no power over a third-party corporate 401k administrator. Retirement accounts are protected by strict federal laws, primarily the Employee Retirement Income Security Act, which aggressively prevents anyone other than the account holder from accessing the funds. A QDRO is the only legal instrument powerful enough to pierce that federal shield. It is a highly specialized, separate legal document that must be drafted, often by a separate attorney specializing in pension law, approved by the judge, and then crucially accepted by the specific corporate plan administrator governing the 401k. Let us examine the potential outcomes when the mechanics of the QDRO collide with the volatility of the modern market. Meet Robert, a 52-year-old engineer facing a divorce in 2026. Robert and his spouse agree to an equal split of his 401k, which is valued at $800,000 on the date of their official separation. Robert assumes his ex-spouse will receive $400,000, and he will retain the rest. He signs the divorce decree, feeling a sense of closure. But the QDRO drafting process takes 4 months. The plan administrator takes another 2 months to review and approve it. Historical trends indicate that nearly half of all initial QDRO submissions are rejected by plan administrators for minor clerical errors, causing even further delays. During those 6 months, a severe economic correction hits the markets. The total value of the portfolio plummets from $800,000 to $600,000. If the QDRO was drafted focusing on a flat dollar amount of $400,000 based on the separation date rather than a percentage, the ex-spouse still receives that exact sum. The plan administrator liquidates 2/3 of the decimated portfolio to fulfill the federal order. Robert is left with $200,000, effectively bearing 100% of the market loss while his ex-spouse suffers none. His supposed equal split organically transformed into a devastating disproportionate loss because he failed to understand the temporal lag and market exposure inherent in the execution process. He becomes the newest protagonist in a modern financial tragedy. The psychological devastation in these scenarios is profound because the 401k is fundamentally different from a standard checking account. It is the quantification of future freedom. When an individual watches an ex-spouse legally extract decades of compound interest through a QDRO, they are not just losing current purchasing power. They feel they are losing the actual years of their life they spent working to generate that wealth. They are watching their planned retirement age get pushed back from 60 to 72 in real time. This dynamic breeds a unique, toxic resentment that fuels the darker variations of these folk narratives, where spouses engage in scorched earth litigation tactics out of sheer desperation. But the market lag we just explored is merely the surface layer of the danger. The true, hidden peril lies deep within the bureaucratic architecture of the corporations that manage these funds. What happens when the company controlling your entire financial future flatly refuses to honor the judge's signature because of a single misplaced sentence in a 50-page plan document you have never read? And more terrifyingly, what are the irreversible tax landmines that wait to detonate the moment those funds are finally moved, potentially wiping out a massive percentage of your net worth in a legally mandated wealth transfer to the Internal Revenue Service? To grasp the sheer destructive power of these tax landmines, we have to look past the courtroom drama and examine the silent, bureaucratic machinery of the corporate plan administrator. In American folklore, the battle is always between the two divorcing spouses. The hero and the villain are clearly defined. But the legal reality of 2026 introduces a faceless, immovable third party, the corporate fiduciary. Whether your account is held at Fidelity, Vanguard, or Charles Schwab, that institution does not work for you, they do not work for your ex-spouse, and they certainly do not care about the emotional fairness of your divorce decree. Their sole legal obligation is to comply with the Employee Retirement Income Security Act and the highly specific, incredibly dense plan document drafted by your employer. This creates a terrifying bottleneck. Consider the case study of Sarah, a logistics director living in Texas in 2026. After a grueling 2-year divorce, Sarah and her ex-husband finally agree that he will receive exactly 50% of her 401k balance. The judge signs the decree, the attorneys draft the qualified domestic relations order, and they submit it to Sarah's company plan administrator. In the folklore version, the money transfers the next day. In reality, the administrator rejects the order entirely. Why? Because Sarah had taken out a $15,000 401k loan 3 years prior to repair a roof. The QDRO drafted by her ex-husband's attorney failed to explicitly state whether the 50% division applied to the gross account balance including the outstanding loan, or the net account balance excluding it. Because of that single missing clarification, the document was deemed non-compliant with the specific corporate plan document. It took another 4 months of billable attorney hours to revise, resubmit, and approve the order. In the world of high-stakes asset division, ambiguity is not just an inconvenience. It is a financial hemorrhage. But the true devastation occurs the moment the plan administrator finally accepts the order and prepares to move the funds. This is where the most dangerous trap in the entire American retirement system is triggered: the 20% mandatory withholding rule. Let us look at historical trends and a highly common scenario. Imagine if a spouse, let us call him David, is awarded $200,000 from his ex-wife's traditional 401k. David is exhausted from the divorce. He wants a clean break. When the plan administrator asks how he wants the money dispersed, David requests a check made out to his name, fully intending to deposit it into his own personal individual retirement account the following week. This single, seemingly logical decision instantly triggers a catastrophic tax event. Because David did not request a direct, institution-to-institution transfer, known legally as a direct trustee-to-trustee rollover, the Internal Revenue Service mandates that the plan administrator automatically withhold 20% of the total distribution for federal taxes. The check that arrives in David's mailbox is not for $200,000. It is for $160,000. Now, David faces a rapidly closing 60-day window. To avoid massive penalties, the IRS requires him to deposit the entire original amount, the full $200,000, into his new IRA within 60 days. But he only has $160,000. To make the account whole and avoid the tax penalty, David must somehow find $40,000 of his own cash to deposit into the IRA, hoping to get it back as a refund when he files his taxes the following year. If he cannot produce that $40,000 out of thin air in 60 days, the IRS classifies that withheld $40,000 as a permanent, taxable early withdrawal. David will owe ordinary income tax on that money, plus a mandatory 10% early withdrawal penalty. By simply checking the wrong box on a distribution form, David permanently vaporized tens of thousands of dollars of generational wealth. These are the outcomes that generate the bitter, cautionary tales whispered in corporate break rooms. They are born from a fundamental illiteracy regarding how pre-tax and post-tax assets behave in the wild. Our culture trains us to look at a net worth spreadsheet and view all numbers equally. If you see $500,000 in a checking account and $500,000 in a traditional 401k, the human brain interprets those as equal assets. Family court attorneys rely on this psychological blind spot during negotiations. Imagine if you are sitting at the mediation table. You are offered a choice. You can keep the fully paid-off marital home, currently valued at $500,000, or you can keep your $500,000 traditional 401k. To the untrained eye, this is a perfectly equitable split. You choose the 401k because you value liquid retirement security, and your ex-spouse takes the house. You believe you have walked away with an equal share of the marital empire. You have not. You have just negotiated yourself into a massive hidden deficit. The marital home, assuming it meets the criteria for the primary residence capital gains exclusion, is a tax-free asset. When your ex-spouse sells that house, they keep the $500,000. But your traditional 401k is a pre-tax asset. You have a silent, invisible partner in that account, the federal government. When you retire and begin withdrawing that $500,000, every single penny will be taxed as ordinary income. If your effective tax rate in retirement is 24%, your actual purchasing power is only $380,000. You unknowingly traded a $500,000 tax-free asset for a heavily taxed liability, simply because you failed to discount the future tax burden of the retirement vehicle. This illusion of equality is the cornerstone of the financialized divorce. The cultural narratives fail to warn us that a dollar is not always a dollar. A dollar in a Roth IRA is fundamentally different from a dollar in a traditional 401k, which is fundamentally different from a dollar of home equity. When these different species of money are thrown into the blender of equitable distribution, the person who understands the tax code always walks away with the heavier half, while the person who relied on the folklore walks away holding an empty bag of future tax liabilities. But even these complex tax landmines pale in comparison to the deepest, most opaque layer of the modern corporate compensation package. What happens when the wealth you are trying to divide doesn't actually exist yet? What happens when the court demands half of an asset that is completely invisible, locked behind a corporate vesting schedule, or tied to performance metrics that haven't been met? We are about to enter the darkest, most volatile corner of the modern divorce, where lawyers must argue over the exact monetary value of a ghost. The ghost in the machine of modern corporate compensation is the unvested asset. In the folklore of the American break room, the prevailing wisdom is strictly binary. You either own the money or you do not. If you log into your retirement portal and see a balance of $400,000, but the fine print notes that $100,000 of that is an unvested employer match, the common sense assumption is that the unvested portion is legally untouchable in a divorce. After all, it requires your future labor to materialize. If you resign tomorrow, that $100,000 vanishes back into the corporate treasury. It is a phantom. Therefore, the cultural narrative dictates that your soon-to-be ex-spouse cannot possibly lay claim to money that you yourself do not even possess yet. This assumption is one of the most financially catastrophic mistakes an individual can make in family court. The legal system of 2026 does not view unvested retirement matches, restricted stock units, or stock options purely as incentives for your future labor. Instead, historical trends in equitable distribution jurisdictions show that judges increasingly view these phantom assets as deferred compensation for marital effort. The logic is brutal and precise. If the corporate grant was awarded during the span of the marriage, the underlying labor that earned that grant was supported by the marital partnership. Therefore, the ghost has a legally enforceable monetary value today, and your spouse is entitled to a portion of its future materialization. Let us ground this complex legal theory in a devastatingly common case study. Imagine if we look at the life of Marcus, a software engineering director living in Illinois in the year 2026. Marcus has spent 6 years at a major tech conglomerate. His compensation package is heavily leveraged toward the future. He has a traditional 401k with a balance of $300,000, but his company uses a graded vesting schedule for their aggressive employer match. Currently, $75,000 of that match is entirely unvested. Furthermore, he was awarded $200,000 in restricted stock units 2 years ago, which do not cliff vest until next year. Marcus enters divorce proceedings operating under the folklore of singular ownership. He sits at the mediation table and declares that his ex-wife, Elena, is only entitled to half of his vested 401k balance, roughly $112,000. He considers the unvested match and the future stock units completely off the table. He is immediately hit with the harsh reality of the time rule, a legal formula used by courts across the country to mathematically divide ghosts. Elena's forensic accountant introduces a terrifying fraction to the court. The numerator is the total number of months Marcus and Elena were married between the date the unvested assets were granted and the date of their legal separation. The denominator is the total number of months between the date of the grant and the future date when the assets will finally vest. This fraction determines the precise marital portion of an asset that does not yet exist. Because Marcus received these grants in the middle of his marriage, a massive percentage of his future unvested wealth is instantly classified as marital property. But here is where the scenario descends into an absolute logistical nightmare, creating the suffocating dynamic known in legal circles as the liquidity trap. The judge agrees with Elena's accountant. Marcus legally owes Elena 50% of the marital portion of both the unvested 401k match and the unvested stock units. However, Marcus cannot simply transfer this money to her today, via a qualified domestic relations order, because the assets are unvested. The corporate plan administrator will reject any attempt to distribute funds that belong to the company until the vesting date arrives. To solve this, the court orders the creation of a constructive trust. This is a legal mechanism that essentially drafts Marcus into becoming a mandatory, unpaid portfolio manager for his ex-wife. He is ordered to hold on to his employment, and when the 401k match eventually vests, and when the stock units finally convert into real shares next year, he must immediately liquidate Elena's exact designated percentage and transfer the cash to her, known as an if as and when distribution. The psychological toll of this potential outcome is immense. Marcus is now wearing what family law attorneys call the iron handcuffs. He hates his job and wants to leave the company to start his own consulting firm. But if he resigns before the vesting dates, he forfeits the unvested 401k match and the stock units entirely. In the eyes of the family court, if he voluntarily quits and destroys an asset that he was ordered to hold in a constructive trust for his ex-wife, he could be found in contempt of court. Elena could successfully sue him for breach of fiduciary duty, claiming he intentionally destroyed her marital property out of spite. The court could then order Marcus to pay Elena the projected value of those lost assets out of his own current, liquid savings. Marcus is effectively trapped in his corporate role, forced to perform future labor solely to generate a payout for a marriage that has already ended. Furthermore, the tax mechanics of this constructive trust are a minefield of potential liabilities. When those restricted stock units vest next year, they are taxed as ordinary income directly to Marcus, driving his personal tax bracket into the highest marginal tier. He must ensure his divorce decree explicitly outlines that he is to transfer the net, after-tax proceeds to Elena, not the gross value. If the decree was poorly drafted by an attorney who did not understand complex compensation structures, Marcus could be legally forced to pay Elena the gross value of the vesting shares, while personally absorbing the massive, six-figure income tax liability levied by the Internal Revenue Service. He would essentially be paying his ex-wife with money he owes to the government. These are the dark, highly technical realities that the campfire stories of the corporate break room completely fail to capture. The folklore warns you about losing half of what you have. It completely neglects to warn you about being legally bound to forfeit half of what you are going to earn in the future, while simultaneously bearing the entirety of the tax burden and the career immobility required to generate it. We have now meticulously mapped the visible battlefield. We have exposed the tax landmines buried in standard 401k distributions, and we have illuminated the phantom assets hidden within corporate vesting schedules. We have seen how forensic accountants use the time rule to extract value from the future. But all of these mechanisms, no matter how brutal, rely on one fundamental assumption: that all the assets, both vested and unvested, are actually known to the court. What happens when the folklore takes a darker turn? What happens when a spouse decides that the only way to win the game is to ensure the assets never make it to the financial disclosure forms in the first place? We are about to cross the threshold from legal maneuvering into deliberate financial concealment, exploring the underground economy of the modern divorce, where 401k loans are weaponized to fund untraceable shadow accounts, and the burden of proof becomes an impossible, agonizing pursuit. The transition from legal maneuvering to deliberate financial concealment marks the darkest chapter in the modern American divorce. In the whispered folklore of the corporate break room, the narrative suddenly shifts from tales of bureaucratic incompetence to chilling stories of premeditated financial sabotage. We are stepping out of the light of the family court and descending into the underground economy of marital dissolution. Here, the 401k is no longer viewed as a passive retirement vehicle. It is actively weaponized as a federally sanctioned, highly liquid credit facility used to systematically drain the marital estate before the legal battle even begins. To understand this subterranean tactic, we must analyze a feature of the American retirement system that was originally designed as a safety net: the 401k loan provision. Under current Internal Revenue Service guidelines, an employee can typically borrow up to 50% of their vested account balance, up to a maximum of $50,000. In the context of a healthy marriage, this is an emergency lever pulled during times of medical crisis or sudden unemployment. But in the context of a collapsing marriage, it becomes the ultimate stealth extraction tool. Because the employee is borrowing from their own account, there is no credit check, no underwriting process, and most dangerously, no mandatory spousal consent required in many corporate plan documents. A spouse can quietly authorize the extraction of $50,000 of marital wealth from an entirely digital interface while sitting at their desk on a Tuesday afternoon. Let us examine a highly representative case study to illustrate the terrifying potential outcomes of this maneuver. Imagine if we look at the timeline of David and Sarah, a couple living in Florida in the current year 2026. David is a senior project manager who silently realizes his marriage is irreparably broken. However, he does not immediately file for divorce. Historical trends in high-conflict separations indicate a planning phase that often precedes the actual legal filing by 12 to 18 months. David enters this shadow phase. 14 months before Sarah is even aware a divorce is imminent, David logs into his corporate portal and initiates a maximum $50,000 401k loan. The funds are electronically deposited into his primary checking account. If he simply transferred that money to a secret offshore account, it would be instantly detected during the mandatory financial discovery phase of the eventual divorce. Instead, David engages in a sophisticated process of financial diffusion, a tactic heavily featured in the darker corners of divorce folklore. Over the next 14 months, he methodically siphons the $50,000 through entirely plausible, mundane channels. He begins overpaying his estimated quarterly taxes to the federal government, essentially using the Internal Revenue Service as a zero-interest, hidden savings account that he will later reclaim as a massive refund after the divorce is finalized. He pays for expensive, unrecorded home repairs in cash, utilizing a network of friendly contractors who agree to hold the capital and refund it later under the table. He purchases highly liquid, untraceable assets like high-grade physical gold coins, disguising the transactions as a newfound numismatic hobby, and stores them in a private, non-bank safety deposit box. By the time the year 2026 arrives and the divorce papers are finally served, the $50,000 has completely vanished into the ether. But the financial devastation inflicted on Sarah is actually twofold. When the family court calculates the total value of the marital estate, they look at the current balance of the 401k. Because of the loan, the balance is $50,000 lower than it should be. Furthermore, David argues that the outstanding 401k loan is a legitimate marital debt, incurred during the marriage, and therefore Sarah should be responsible for half of the repayment. Through a single premeditated digital action, David successfully extracted $50,000 of untraceable wealth for himself, reduced the visible marital assets, and attempted to saddle his ex-wife with half the liability of the theft. This brings us to the agonizing concept of the burden of proof, the legal reality that shatters the myth of automatic courtroom justice. In American folklore, the judge is an omniscient figure who magically uncovers hidden truths. In the reality of a 2026 family court, the judge only knows what can be forensically proven on paper. When Sarah discovers the missing funds and accuses David of intentional concealment, known legally as the dissipation of marital assets, the court does not automatically take her side. The burden of proof rests entirely on her shoulders to trace exactly where that money went. This is where the mathematical nightmare of the financialized divorce truly begins. To prove dissipation, Sarah's attorney must hire a forensic accountant to conduct a comprehensive lifestyle analysis and a source and use of funds audit. The accountant will have to subpoena bank records, analyze years of credit card statements, and attempt to reconstruct David's cash flow to prove that the $50,000 was not spent on legitimate marital expenses. Historical trends show that the retainer for a qualified forensic accountant in a complex marital asset case can easily exceed $20,000 to $30,000. Sarah is now trapped in the most brutal paradox of the modern legal system. She must spend $30,000 of her remaining liquid capital to potentially recover $50,000 of stolen retirement funds. And there is absolutely no guarantee of success. If David is sophisticated enough to successfully obfuscate the paper trail, claiming the money was lost in legitimate day trading, failed investments, or an escalating gambling addiction, the court may find the evidence inconclusive. The system unintentionally rewards the sophisticated concealer, provided the stolen amount sits within the uncanny valley of litigation. An amount large enough to be devastating to the victim, but just small enough that the forensic fees required to recover it render the pursuit mathematically illogical. The realization that justice is fundamentally constrained by liquid capital is the most traumatic psychological blow in these folk narratives. The victim's spouse realizes that the 401k, the fortress they thought they were building together, was actually equipped with a trapdoor that only the account holder knew how to operate. They are left with the hollow victory of knowing they were robbed, but lacking the financial ammunition to prove it to the state. Folklore surrounding these hidden accounts is not mere paranoia. It is a vital cultural warning system about the extreme vulnerability of assets that exist purely as data points on a corporate server. But even if you manage to avoid the trapdoors of 401k loans and shadow accounts, and even if your spouse operates with complete transparency, you are still entirely at the mercy of the most volatile and unpredictable variable in the entire financial ecosystem. What happens when the underlying value of the 401k itself begins to violently fluctuate, while you are trapped in a 2-year legal holding pattern? We are about to examine the devastating consequences of the valuation date, a seemingly minor administrative detail that has the power to organically redistribute hundreds of thousands of dollars of wealth overnight, depending entirely on the unpredictable whims of the global stock market. The great illusion of the American financialized divorce, directly tied to these market whims, is what we can call the freeze frame myth. In the traditional folklore of the corporate break room, the prevailing assumption is that the moment you utter the word divorce, or the moment you physically move out of the marital home, a giant, invisible pause button is pressed on your financial life. The human brain desperately wants to believe that the ledger is permanently locked on that specific day. You look at your 401k portal, you see a balance of $500,000, and you construct your entire legal strategy and emotional expectation around that exact number. But the legal reality in the United States in the year 2026 is that the judicial system does not possess a pause button for the global economy. Your retirement account remains a live, breathing, highly volatile entity, completely exposed to the relentless machinery of Wall Street throughout the entirety of your legal proceedings. This introduces the concept of the valuation date, a seemingly mundane administrative detail that regularly destroys the financial futures of unsuspecting individuals. In family law, the exact date an asset is valued for division is not universally standardized by federal law. It is entirely dependent on the specific jurisdiction, the historical trends of case law in that particular state, and sometimes the sole discretion of a single family court judge. Some states mandate the valuation date is the date of physical separation. Others rule it is the date the initial divorce petition was filed. Still, others insist the only fair date is the final date of the trial or the exact date the assets are officially distributed. Let us examine the catastrophic potential outcomes of this ambiguity through a detailed case study. Imagine if we follow the timeline of Michael and Jessica, a couple navigating a high-asset divorce in 2026. Michael is a software engineer whose 401k is heavily concentrated in volatile, large-cap technology index funds. On the date they officially separate and Michael moves into an apartment, his 401k portal shows a vested balance of exactly $600,000. Operating under the freeze frame myth, Michael assumes Jessica is entitled to $300,000, and he begins mentally planning his newly single life based on retaining the other half. However, high-conflict divorces are not swift. Due to court backlogs and aggressive discovery disputes, Michael and Jessica do not reach a final settlement trial until 24 months after their initial separation. During those 2 years, a massive, unprecedented bull market sweeps through the technology sector. By the time they are sitting in front of the judge, Michael's 401k has surged to a balance of $900,000 purely through passive market appreciation. He has not contributed a single new dollar of his post-separation income to the account, but the underlying assets have organically swelled. This is where the folklore violently collides with the courtroom reality. Michael's attorney argues fiercely for the date of separation to be used as the valuation date, claiming that the marriage effectively ended 2 years ago and Jessica has no right to the subsequent $300,000 of growth. Jessica's attorney counters with historical trends from their specific state, arguing that because the asset was legally undivided during the separation, Jessica remained a passive, involuntary investor in that account, assuming 50% of the market risk. Therefore, she is entitled to 50% of the market reward. If the judge sides with Jessica and uses the date of trial as the valuation date, Michael instantly loses an additional $150,000 of wealth that he believed was entirely his separate property. The administrative choice of a calendar date fundamentally rewrote his financial destiny. But this scenario, while painful for Michael, is actually the less destructive variation of the valuation trap. To understand the true horror stories whispered among the newly divorced, we must look at the inverse scenario, the fixed dollar trap during a market collapse. Imagine if we alter the case study. Michael and Jessica reach a settlement agreement relatively quickly. They agree to use the separation date value of $600,000 to create a clean, seemingly simple divorce decree. Their attorneys draft an agreement stating that Jessica will receive a fixed sum of $300,000 from Michael's 401k. The judge signs the decree. Michael feels a profound sense of relief. He believes the battle is over. But as we explored previously, the judge's signature does not move the money. The attorneys must now draft the qualified domestic relations order, submit it to the corporate plan administrator, and wait for bureaucratic approval. This process takes 4 months. During those 4 agonizing months, a severe geopolitical crisis triggers a global market correction. The technology sector plummets. The total value of Michael's 401k drops from $600,000 down to $400,000. Finally, the plan administrator approves the order and prepares to disburse the funds to Jessica. Because the legally binding decree specifically ordered a flat dollar transfer of $300,000, rather than a percentage-based division, the corporate administrator is legally obligated to fulfill that exact numerical order. They do not care that the market crashed. They do not care about fairness. They execute the trade, liquidating 3/4 of Michael's remaining portfolio to generate the required $300,000 in cash for Jessica. Michael is left with an account balance of $100,000. He entered the process believing he was surrendering 50% of his retirement. Due to a combination of market volatility, administrative lag, and the catastrophic legal error of using a fixed dollar amount instead of a percentage formula in the drafting of the settlement, Michael organically absorbed 100% of the market loss. Jessica walked away completely insulated from the crash, receiving her full designated value, while Michael's remaining decades of compound interest were effectively vaporized in a matter of weeks. This is the hidden mathematics of the modern financialized divorce. You are not just negotiating with your ex-spouse, you are negotiating against time, bureaucracy, and the global economy. The cultural narrative teaches you to fight over who gets what, but it completely fails to teach you to fight over exactly when the what is measured and precisely how the transfer is insulated against the passage of time. These historical trends reveal a terrifying reality. During the pendency of a divorce, your life savings are essentially being day traded by the speed of the judicial calendar. You are forced to hold a highly volatile position in the market, while completely stripped of your ability to manage the risk. But as complex and dangerous as standard index funds and tech stocks are within this legal labyrinth, they are still fundamentally liquid. They can be sold with the click of a button. What happens when the assets inside the retirement account cannot be quickly sold? What happens when a sophisticated spouse utilizes legal loopholes to transition those 401k funds into highly illiquid, alternative investments right before the divorce begins? We are about to cross into the most complex and impenetrable layer of marital asset division, where the court orders the splitting of assets that physically cannot be split without destroying their entire underlying value. The transition from easily divisible index funds to highly illiquid, alternative investments is the most sophisticated and destructive maneuver within the modern marital dissolution. In the years leading up to 2026, historical trends indicate a massive, unprecedented surge in knowledgeable individuals moving their standard, corporate-sponsored 401k funds into specialized tax-advantaged vehicles. These are most commonly self-directed individual retirement accounts or solo 401ks designed for independent contractors and business owners. The mainstream cultural folklore celebrates this as a narrative of ultimate empowerment, describing it as taking total control of your financial destiny, escaping the volatility of Wall Street, and investing your pre-tax dollars into tangible physical reality. But in the cold, unforgiving shadow of family law, this exact maneuver is frequently weaponized as an impenetrable defensive fortification against equitable distribution. Imagine if you are going through the mandatory financial discovery phase of a divorce. You log into the portal of your spouse's retirement account, fully expecting to see a neat, easily understandable list of publicly traded mutual funds and corporate bonds. Instead, you are confronted with a single baffling line item: a 100% ownership stake in a private limited liability company. This is the self-directed checkbook control strategy. The retirement account itself does not hold stocks. It holds a legal entity, and that legal entity holds physical, deeply illiquid, and heavily guarded alternative assets. Let us explore the devastating potential outcomes of this strategy through the detailed case study of Thomas and Amanda, a couple navigating a high-conflict divorce in Georgia in the year 2026. Thomas is a successful commercial contractor. Sensing deep marital turbulence 3 years prior to the official separation, Thomas rolled a massive legacy 401k from a previous corporate career into a self-directed solo 401k. He then utilized those tax-deferred funds to purchase a 40% fractional ownership stake in a private, unlisted commercial real estate syndication. Specifically, his retirement account now owns 40% of a highly profitable, privately held industrial park. When the divorce proceedings inevitably commence, the family court demands an immediate and precise valuation of the entire marital estate. If Thomas held $4 million in publicly traded technology stocks, The valuation would take precisely 3 seconds to verify on the open market. Because he holds a minority stake in a private real estate syndication locked inside a retirement wrapper, the valuation process instantly descends into a multi-month, 6-figure war of attrition between opposing forensic accounting experts. Amanda's legal team hires a highly aggressive commercial appraiser who analyzes the cash flow of the industrial park and argues that Thomas's 40% share is currently worth $3 million. Thomas's attorney counters by deploying a specialized business valuator who introduces a crushing, wealth-destroying mathematical concept known as the discount for lack of marketability, deployed directly alongside a minority interest discount. Thomas's expert stands before the family court judge and argues a highly technical but completely legal reality. Because Thomas only owns 40% of the industrial park, he holds absolutely no controlling voting rights. He cannot unilaterally force the majority owners to sell the building or liquidate the asset. Furthermore, there is no public stock exchange for this highly specific fractional share of a Georgia industrial park. You cannot simply log into a brokerage account and sell it to a retail investor. Therefore, the expert insists the actual fair market value must be severely penalized to account for this extreme illiquidity and lack of control. The court, bound by historical trends in business valuation case law, often accepts this logic. Through pure, legally sanctioned financial alchemy, an asset that generates massive real-world cash flow is mathematically compressed on paper. The court applies a 40% discount, legally reducing the visible value of the asset from $3 million down to $1.8 million. In a single afternoon of expert testimony, Amanda's potential settlement is reduced by hundreds of thousands of dollars before a single asset is even divided. But the true, inescapable nightmare materializes when the judge finally issues the order to physically divide the asset. Let us assume the judge rules that Amanda is legally entitled to $900,000, representing half of the discounted value of the syndication. Thomas does not have $900,000 in liquid cash sitting in a checking account to buy her out. The private syndication agreement strictly and explicitly prohibits Thomas from transferring his shares to any non-accredited, unapproved external party like his ex-wife. And crucially, the family court judge has absolutely no legal jurisdiction to force the other 60% owners of the industrial park to sell their entire, profitable property just to satisfy Thomas's personal marital obligations. The court is now faced with an impossible geometric puzzle. It has legally ordered the division of an entirely indivisible object. The potential outcomes in this scenario are uniformly catastrophic for the preservation of generational wealth. The first potential outcome is the judicially mandated fire sale. Thomas is ordered by the court to liquidate his minority position at any cost necessary to generate the cash for Amanda. Because he is legally distressed and compelled by the state to sell a highly illiquid asset on a strict, ticking timeline, private equity firms and opportunistic buyers swoop in. They refuse to pay the fair market value. Knowing Thomas has no negotiating leverage, they purchase his share for pennies on the dollar. Decades of compounded, tax-deferred wealth are entirely incinerated in a matter of weeks to satisfy the blind liquidity demands of the family court system. The second potential outcome is even more psychologically terrifying for the individuals involved. It is the dreaded in-kind transfer. If the operating agreement of the syndication contains a loophole that allows it, the judge may simply order Thomas to transfer half of his fractional shares directly into a newly created self-directed IRA for Amanda. The divorce decree is signed, the marriage is legally terminated, but Thomas and Amanda are now permanently, legally bound together as fractional business partners in a massive commercial real estate venture. Every single time the industrial park needs a multi-million-dollar roof repair, every time a capital call is issued by the majority owners to fund an expansion, Thomas and Amanda must communicate, coordinate, and financially bleed together. The family court has successfully severed the romantic union, but inadvertently forged a permanent, inescapable financial chain between two people who fundamentally despise each other. This is the impenetrable, suffocating layer of the financialized divorce that the cultural narratives desperately attempt to warn us about. When the folklore speaks of wealthy spouses who suddenly hide their money in confusing, shadowy companies, it is rarely outright fraud. It is a profound misunderstanding of complex, legally permissible wealth architecture. When a collapsing marriage intersects with alternative assets, private equity, and self-directed retirement vehicles, the standard, predictable rules of equitable distribution completely collapse. The legal system is fundamentally designed to divide liquid cash and publicly traded securities. When it is forced to process an industrial park locked inside a tax-deferred corporate wrapper, the mechanical justice simply grind the underlying asset into absolute dust. We have now seen how the struggles to divide the indivisible, and how forensic accounting can make millions of dollars disappear entirely on paper. But throughout this entire exhaustive masterclass, we have operated under one massive overarching assumption. We have assumed that the family court judge, the highly paid attorneys, and the state legislature actually possess the ultimate final authority to decide exactly where your retirement funds go. What if I told you that there is a single simple document, completely separate from your divorce decree, your last will and testament, and your living trust, that possesses a terrifying absolute federal supremacy? A document that completely overrides the family court, entirely ignores the judge's signature, and has the absolute legal power to transfer your entire 401k to a complete stranger, even if you have been happily married for 30 years. Before we begin, a quick and important disclaimer. The following presentation involves deep examinations of family law, marital asset division, and complex financial instruments, specifically the American 401k retirement plan. However, the information provided in this video is strictly for educational, cultural, and entertainment purposes. I am an independent cultural researcher and storyteller, not a licensed family attorney, a certified financial planner, a fiduciary, or a tax professional. The narratives, historical trends, case studies, and potential outcomes discussed throughout this series do not, under any circumstances, constitute professional legal or financial advice. Laws regarding divorce, equitable distribution, community property, and retirement asset division vary drastically by state and jurisdiction. You must conduct your own rigorous due diligence and consult with qualified, licensed legal counsel and financial advisors regarding your specific personal circumstances before making any decisions regarding marriage, divorce, or asset management. The document in question is not kept in a mahogany desk or a leather-bound folio. It is a sterile digital 2-page electronic form buried deep within a corporate human resources portal. It is the 401k beneficiary designation form. In the mythology of the American family, the last will and testament is viewed as the absolute, unbreakable final word on a person's legacy. The culture teaches us that a meticulously drafted will, signed in the presence of witnesses and a notary, dictates exactly how a lifetime of wealth will be distributed. But this is a profound and dangerous legal illusion. A standard will only governs assets that pass through the state probate court system. Your 401k is fundamentally different. It is a non-probate asset, entirely governed by the Employee Retirement Income Security Act, a federal law enacted in 1974. And under the United States Constitution, federal law possesses absolute preemption over state law. This means that your state-level family court divorce decree, your state-level prenuptial agreement, and your state-level last will and testament are completely subordinate to the federal rules governing that single corporate document. To fully grasp the sheer mechanical ruthlessness of federal preemption, we must examine a highly representative case study based on well-established historical trends in federal litigation. Imagine if we look at the life of Arthur and his second wife, Margaret, living in Ohio in the year 2026. Arthur and Margaret have been happily married for 28 years. Arthur is a senior mechanical engineer who has worked for the same large industrial manufacturing corporation his entire adult life. He has diligently contributed to his 401k for 4 decades, amassing a balance of $1.4 million. Arthur has done everything the cultural folklore dictates a responsible provider should do. He hired an expensive estate planning attorney, drafted a comprehensive living trust, and executed a flawless will that explicitly leaves 100% of his entire earthly estate to Margaret. Tragically, Arthur suffers a fatal heart attack in 2026. Margaret, while grieving, feels a sense of profound financial security, knowing Arthur meticulously planned for her survival. She contacts the corporate plan administrator to claim the $1.4,401,000 balance. But instead of receiving a transfer of funds, she receives a sterile bureaucratic denial letter. The corporate administrator informs Margaret that she is not the legal beneficiary of the account. To unravel this mystery, we have to look back 40 years. When Arthur first started his job at the age of 22, he was briefly married to his high school girlfriend, a woman named Linda. During his first week of employee onboarding, he filled out a paper beneficiary designation form and wrote Linda's name on the primary beneficiary line. 2 years later, Arthur and Linda underwent a bitter but highly thorough divorce. Their state family court divorce decree explicitly and legally stated that Linda permanently waived any and all rights to Arthur's retirement accounts, pensions, and future corporate benefits. Following the divorce, Arthur and Linda never spoke again. When Arthur married Margaret years later, he updated his will, his life insurance, and his bank accounts. He simply forgot to log into the corporate portal to update that one specific 401k form. Margaret assumes this is a simple administrative error. She hires an attorney and presents the corporate plan administrator with Arthur's last will and testament, leaving everything to her. The administrator rejects it. Margaret then presents the airtight state divorce decree from 40 years ago, proving that Linda legally waived her rights to the money. The administrator rejects that as well. Margaret is forced to file a federal lawsuit, fully believing that no rational judge would award $1.4 million to a woman Arthur divorced 4 decades ago, especially when his will explicitly names his wife of 28 years. This is where the folklore shatters against the immovable wall of the Supreme Court of the United States. Historical trends in these exact disputes consistently yield the exact same brutal potential outcomes. The federal court rules against Margaret and orders the corporate plan administrator to write a check for $1.4 million to Linda, the ex-wife. The logic behind this legal mechanism is mathematically cold and entirely focused on corporate efficiency rather than human fairness. The federal government decided long ago that it is fundamentally impossible for a massive corporation managing thousands of employee accounts to act as a private investigator every time an employee dies. If plan administrators were legally required to cross-reference every death claim with state divorce decrees, probate court rulings, and shifting family dynamics across 50 different states, the entire American retirement system would immediately collapse under the weight of infinite litigation. Therefore, federal law explicitly mandates the plan document rule. The corporate plan administrator is legally required to look at one thing and one thing only: the name written on the most recent beneficiary designation form on file. They are legally prohibited from looking at your will. They are legally prohibited from reading your divorce decree. If the form says Linda, the administrator must pay Linda, even if Linda legally waived her right to the money in a state court 40 years prior. The federal court determines that it was Arthur's sole responsibility to update his corporate forms, and his failure to do so is not the corporation's problem. The psychological devastation inflicted upon Margaret in this scenario is absolute. She is forced to watch her financial survival, a fortress built over 3 decades of a loving partnership, legally confiscated and handed to a complete stranger based on a microscopic clerical oversight. Linda, the ex-wife who contributed absolutely nothing to the 28 years of wealth accumulation, walks away with $1.4 million in legally protected, unrecoverable cash. And because the asset was transferred under federal law, Margaret has virtually no legal avenue to sue Linda to return the funds. The money is simply gone, evaporated into the ether by a 40-year-old signature. This structural reality transforms the 401k from a vehicle of ultimate security into a ticking administrative time bomb. The cultural narratives surrounding marriage and divorce fail entirely to prepare individuals for the fact that they are operating under 2 completely different, often conflicting legal systems simultaneously. You can spend hundreds of thousands of dollars fighting in family court, negotiating every last penny of your marital estate, only to have the entire settlement completely invalidated the moment someone passes away because a digital form in a server farm in Delaware was never updated. We have now exposed the hidden traps of asset valuation, the dangers of corporate vesting schedules, the underground economy of 401k loans, and the terrifying supremacy of federal beneficiary forms. We have mapped the entire battlefield of the financialized divorce. But everything we have discussed so far assumes that the individuals involved still have one crucial resource left: time. We have assumed they have the time to rebuild, the time to let the market recover, and the time to generate new income. What happens when a marriage collapses and that final essential resource is already completely exhausted? We are about to enter the most devastating demographic crisis in the modern American financial system, examining the sheer, irreversible mathematics of the late-stage separation, where compound interest becomes a weapon, and the traditional concept of retirement is permanently destroyed. The traditional concept of retirement is permanently destroyed when the sheer, irreversible mathematics of a late-stage separation collide with the realities of the modern economy. In the folklore of the American divorce, the protagonist is almost exclusively depicted as someone in the middle of their career. They are wounded, they are financially devastated, but they possess a silent, invisible safety net: the sheer volume of time left on their biological clock. If a 35-year-old loses half of their retirement portfolio in family court, it is a catastrophic setback, but it is mathematically recoverable. They have 3 decades of labor and compound interest to rebuild the principal. But historical trends from the year 2026 reveal a terrifying demographic shift. The highest accelerating rate of marital dissolution is now found among individuals over the age of 50. This phenomenon, known as the Gray Divorce, completely rewrites the rules of financial survival. In a late-stage separation, time is no longer a safety net. It is an aggressively shrinking window, and compound interest transforms from an engine of wealth creation into a merciless weapon of wealth destruction. To comprehend this brutal mathematical reality, we must deconstruct the fundamental architecture of retirement planning. The entire American 401k system is predicated on achieving a specific critical mass of capital. Financial advisors rely heavily on the 4% rule, a historical baseline suggesting that a retiree can safely withdraw 4% of their total portfolio during their first year of retirement, adjust for inflation annually, and theoretically never run out of money over a 30-year period. This rule relies entirely on the portfolio remaining whole and generating sufficient passive yields to offset the withdrawals. Imagine if we examine the highly representative case study of Richard and Susan, a couple living in Arizona in 2026. Richard is 63 years old, and Susan is 61. After decades of disciplined saving, their combined marital estate consists primarily of a single massive traditional 401k valued at $1.2 million. Operating as a single economic unit, their math is sound. Under the 4% rule, that $1.2 million generates roughly $48,000 of pre-tax income per year. Combined with their anticipated Social Security benefits, they have achieved the American dream. They have enough capital to maintain their suburban home, cover their medical premiums, and enjoy a modest, secure retirement. Then the marriage collapses. They enter the family court system, and the $1.2 million portfolio is subjected to a qualified domestic relations order. It is mathematically severed directly down the middle. Richard walks away with $600,000. Susan walks away with $600,000. In the breakroom folklore, this is perceived as an equitable, fair, and clean division. But the brutal, underlying mathematics dictate that fairness on paper translates directly to poverty in practice. When we apply the 4% rule to their newly severed, individual portfolios, Richard and Susan can now only safely withdraw $24,000 a year each. Their passive income has been exactly halved. However, their living expenses do not experience a corresponding 50% reduction. This is the central unavoidable trap of the late-stage financialized divorce. One household functioning on $48,000 a year is economically viable. 2 entirely separate households, requiring 2 separate rent or mortgage payments, 2 sets of property taxes, 2 utility bills, and 2 sets of maintenance costs, cannot physically survive on $24,000 a year each. The fundamental economies of scale that made their retirement possible have been permanently shattered by the legal decree. Because $24,000 is insufficient to cover their newly duplicated baseline living expenses, Richard and Susan are forced into a mathematically fatal maneuver. They must increase their withdrawal rate just to survive. Instead of withdrawing the safe 4%, they are forced to withdraw 7, 8, or even 10% of their remaining principal every single year to cover their basic overhead. This triggers a catastrophic financial chain reaction, known as sequence of returns risk. Because they are liquidating the principal at an accelerated rate, the remaining balance can no longer generate enough compound interest to replenish the account. They enter a death spiral of capital depletion. If this forced liquidation happens to coincide with a standard bear market or an economic recession in 2026, the destruction is exponentially magnified. They are forced to sell off assets at depressed prices just to pay for groceries and rent. The 401k, which was meticulously designed to last until they were 90 years old, will now be completely exhausted by the time they reach age 74. The traditional concept of retirement is entirely vaporized. The result of this late-stage division is the absolute certainty of returning to the labor force in their late 60s or 70s, competing in an economy that systematically undervalues older workers, simply because the critical mass of their portfolio was legally bifurcated right at the finish line. Furthermore, the Gray Divorce introduces a devastating vulnerability regarding healthcare capital. In the minds of the American public, a 401k is often associated with leisure, travel, and housing. But in the reality of 2026, a massive portion of any retirement portfolio serves as an undeclared, self-funded long-term care insurance policy. The historical trends surrounding medical costs indicate that Medicare contains massive gaps, completely failing to cover assisted living, memory care, or extended in-home nursing. When Richard and Susan held $1.2 million together, they possessed a robust defensive shield against a catastrophic medical event. Either one of them could have utilized the collective capital to fund a multi-year stay in a memory care facility without instantly bankrupting the healthy spouse. By dividing the asset in half, the family court inadvertently destroys this medical shield for both individuals. With only $600,000 each, a single diagnosis of a chronic degenerative illness will completely wipe out their individual remaining capital within 5 to 7 years. They have transitioned from a financially secure, self-insuring unit into two highly vulnerable, isolated individuals entirely exposed to the systemic shocks of the American healthcare industry. This dynamic frequently leads to desperate, high-stakes negotiations during the divorce process itself. Often, one spouse will attempt to negotiate away their right to future alimony payments in exchange for keeping a larger, disproportionate share of the 401k. They want the security of the lump sum over the risk of relying on monthly checks from an ex-spouse who could lose their job or pass away. While this seems logical in the folklore of divorce strategy, it ignores the terrifying tax reality of traditional retirement accounts. If a 62-year-old trades untaxed home equity or guaranteed future cash for a massive traditional 401k balance, they are willingly absorbing a massive future tax liability, right at the exact moment their earning power is permanently declining. They are trading liquid survival capital for a heavily taxed, inaccessible digital vault. We have now analyzed the irreversible mathematical destruction of the late-stage separation. We have seen how the legal division of a portfolio inherently destroys the economies of scale, forces catastrophic early withdrawals, and permanently exposes both individuals to the ravages of medical debt. We have completely dismantled the illusion that a 401k division at age 60 is survivable without fundamentally altering your standard of living. But throughout this entire exhaustive investigation into the mechanisms of family court, corporate bureaucracy, and tax law, there is one final ultimate defense mechanism that wealthy individuals believe will protect them from all of this. What happens when the entire system of equitable distribution is challenged by a pre-existing legal contract? What happens when we introduce the prenuptial agreement into the 401k matrix, only to discover that the document you spent thousands of dollars crafting, the document you thought was completely ironclad, is mathematically and legally useless under specific federal conditions? The illusion of the ironclad prenuptial agreement is the ultimate defensive myth in the folklore of American wealth preservation. In the cultural narrative passed down through high society circles and corporate boardrooms, the prenuptial agreement is viewed as an impenetrable legal fortress. The stories tell of wealthy individuals who wisely spent tens of thousands of dollars retaining the most aggressive family law attorneys in their state to draft a document so comprehensive, so mathematically precise, that it permanently insulates their premarital assets from any future romantic disaster. You sit at a mahogany table, full financial disclosures are exchanged, both parties sign in the presence of witnesses and a notary, and you believe you have successfully opted out of the standard, terrifying rules of equitable distribution. You believe your massive corporate 401k is safe. But this belief relies on a catastrophic misunderstanding of the hierarchy of American law. A state-level prenuptial agreement cannot automatically override a federal statute, and your 401k is governed entirely by the federal government. To understand how a bulletproof legal document is vaporized by a bureaucratic technicality, we must dive into the specific mechanisms of the Employee Retirement Income Security Act, commonly known as ERISA. Passed in 1974, this federal law was designed to protect surviving spouses from being left destitute. Under ERISA, the law explicitly dictates that the moment you become legally married, your spouse automatically becomes the primary beneficiary of your 401k plan, and they possess an inherent, federally protected right to a portion of those funds in the event of a divorce or death. This introduces the most dangerous chronological trap in the entire American legal system. Let us examine the potential outcomes through a detailed case study based on historical trends in high-net-worth divorces. Consider the timeline of William and Elizabeth, a couple residing in New York in the current year 2026. William is a senior pharmaceutical executive holding $3 million in his corporate 401k. 6 months before their wedding, William and Elizabeth agree to a prenuptial agreement. Elizabeth retains independent legal counsel, the negotiations are entirely fair, and 30 days before the wedding ceremony, Elizabeth signs a document explicitly stating she waives any and all current and future rights to William's $3,401,000. William locks the document in a safe, feeling entirely secure. 7 years later, the marriage collapses. During the divorce proceedings, Elizabeth's forensic accountant targets the $3,401,000. William confidently produces the prenuptial agreement, pointing to Elizabeth's signature waiving her rights. But Elizabeth's attorney introduces a terrifying, undeniable federal reality. On the day Elizabeth signed that prenuptial agreement, she was legally classified as William's fiancée. She was not his spouse. Under the strict, literal interpretation of federal ERISA law, only a spouse can waive their rights to a 401k. A fiancé does not yet possess any federally recognized rights to the retirement account. Therefore, in the eyes of the federal government, Elizabeth signed a document waiving a legal right that she did not physically or legally possess at the time of the signature. The state family court judge is bound by federal preemption. The judge must rule that because the waiver was signed before the marriage, it is entirely invalid regarding the federally regulated 401k. Despite spending massive amounts of capital on state-level attorneys to draft a flawless prenuptial agreement, William just lost half of his $3 million retirement account because he failed to understand the precise chronological requirements of federal corporate law. The only way to actually protect a 401k in this scenario involves a highly specific, profoundly uncomfortable two-step process that the cultural folklore almost never mentions. To execute a valid waiver, the prenuptial agreement must include a clause stating that the incoming spouse agrees to sign a federal spousal consent waiver after the wedding. Then the couple must get married. Once the marriage certificate is officially filed with the state, the new spouse must physically log into the corporate plan administrator's portal, download a specific federal waiver form, sign it in front of a specialized notary, and submit it back to the corporation. The psychological and logistical failure rate of this post-wedding maneuver is staggering. Imagine the human dynamics required to execute this. You have just returned from a honeymoon. You are starting a new life together. The absolute last thing anyone wants to do is sit down at a kitchen table and demand their new spouse sign a dense corporate document waiving their rights to millions of dollars of future security. Human nature dictates that individuals procrastinate. They assume the state prenuptial agreement is good enough for now. They plan to fill out the corporate paperwork later. Months turn into years, the form is never downloaded, the federal waiver is never executed, and the legal trap is permanently set, waiting silently in the dark for the marriage to fail. Furthermore, consider the terrifying potential outcome if the new spouse simply changes their mind. Imagine if William returns from the honeymoon and presents Elizabeth with the federal waiver, and she simply refuses to sign it. Because they are already legally married, she now possesses the absolute federal right to the 401k. William cannot force her to sign it. If he attempts to coerce her, the waiver can be invalidated under the legal doctrine of duress. William's only recourse if she refuses to sign the postnuptial waiver is to immediately file for divorce to minimize the accumulation of marital property, essentially ending the marriage mere weeks after it began over a bureaucratic signature. This absolute legal nightmare is exactly why historical trends in advanced wealth management show highly sophisticated individuals utilizing a completely different strategy. They bypass the federal ERISA trap entirely by utilizing the rollover loophole before the wedding invitations are even mailed. If an individual has a massive corporate 401k from a previous employer, they will execute a direct trustee-to-trustee rollover, moving the entire balance out of the federally regulated 401k ecosystem and into a traditional individual retirement account. The cultural folklore incorrectly assumes that an IRA and a 401k are identical simply because they are both tax-deferred retirement vehicles. The legal reality is that they exist in entirely separate universes of jurisdiction. An individual retirement account is generally governed by state law, not federal ERISA law. Therefore, if William had moved his $3 million into an IRA before meeting Elizabeth, a standard state-level prenuptial agreement signed 30 days before the wedding would have successfully and permanently protected the entire asset. The failure to understand the profound legal distinction between the corporate wrapper of a 401k and the individual wrapper of an IRA is the exact microscopic error that redistributes generational wealth in the family court system every single day. We have now systematically deconstructed the entire mythology of the American financialized divorce. We have taken the whispered cautionary tales of the corporate breakroom and anchored them to the cold, undeniable realities of tax code, bureaucratic lag, market volatility, federal preemption, and the devastating mathematics of late-stage separations. You now understand that a divorce is not merely the dissolution of a romantic partnership. It is the forced, highly inefficient liquidation of a joint corporate enterprise. You understand that the folklore is not merely paranoid gossip, but a desperate cultural warning system, attempting to illuminate the invisible landmines buried deep within our modern compensation structures. The modern American worker sacrifices their youth, their time, and their present comfort to build a digital fortress of retirement security, completely unaware that the legal system possesses the master keys to the vault. By mastering the historical trends and potential outcomes we have explored in this masterclass, you are no longer operating in the dark. You possess the financial literacy required to look past the illusion of singular ownership and recognize the complex, multi-layered legal reality of your own net worth. You can now identify the catastrophic difference between a flat dollar settlement and a percentage division, between a pre-tax asset and a post-tax asset, and between a state court decree and a federal beneficiary form. But as we close the ledger on the corporate 401k, a new, entirely unregulated frontier of marital asset division is rapidly emerging on the horizon. We have spent hours discussing wealth that is tracked by corporate administrators, taxed by the federal government, and frozen by state judges. What happens when the wealth in question exists entirely outside of the traditional financial system? What happens when a spouse secretly converts their marital assets into decentralized, cryptographic tokens, memorizes a 12-word seed phrase, and completely vanishes the digital paper trail? We are about to leave the heavily regulated world of Wall Street and enter the absolute anarchy of the blockchain divorce, where forensic accountants must hunt for invisible ledgers, and the family court is forced to reckon with assets that physically cannot be seized.